Usually when I'm interviewed, it happens the way Bran chose me. There's usually a very long initial conversation. And I would say, for me, 8 times out of 10, I establish a collective unconscious. I understand where the attorney is leading, what the attorney wants, what the attorney's looking for. If I can't fulfill what he or she needs, I'll bow out real quick. That's happened a few times. It becomes obvious very early on in the conversation. It also becomes obvious to me that this attorney is questioning me in terms of my knowledge and my familiarity with the courtroom and familiarity with the process, more so he can see that I can walk and talk. We're not talking so much about the specifics of the case. He wants to know that I'm not going to embarrass him in the courtroom. So it's along these lines. And we've had a couple of meetings, one on the telephone, one at his office, where we really went into detail about the specifics and the general idea of where we're heading in terms of valuation and or diminution of value, just in case the other side starts throwing curveballs in cross-examination. So that Bran and I have to be comfortable knowing what each other knows about the topic, so that neither of us are surprised in the courtroom situation.
Well, there's a real marriage, too, between what I'm trying to do and what you do, and being able to work together to... I really find that I'm trying to work with the expert, usually, any expert, to help. I want to convert what they do in a science and just really work on how to explain it to a jury in the way I need it. And it's a process that we sat down once, and I knew we were going to have to sit down again and again, maybe a couple of times, because it's a repetitive type of preparation to blend the two professional kind of aspects coming together, one being a science and one being a form of storytelling.